Welcome, my name is György Kovács. I would like to share some introductory thoughts about intellectual property protection within the EU. First of all, what is the definition of IP? Intellectual property provides an exclusive right to right owners to exclusively manufacture, advertise, sell, distribute and utilize the subject of their IPR for a limited period in the territory of the jurisdiction where protection is applied for. You may ask, what is the reason behind states give exclusive rights to creators over their invention? The reason is that states want to give incentive to creativity. They want to reward creators in order to stimulate growth and jobs in the economy and thereby to contribute to the competitiveness of an economy. A joint study commissioned by the European Commission, the European Patent Office and the European Union Intellectual Property Office in 2014 has revealed the following important connection between IPR and economic growth and job creation. More than a third of jobs in Europe, which is 77 million jobs, depend either directly or indirectly on sectors making intensive use of IP. And these are actually quality jobs, where the remuneration is 40% above the other sectors. And this premium is even higher in copyright-intensive sectors such as audiovisual, the music industry, film industry. There, this premium is almost 70%. Most operators of these IP-intensive sectors actually combine different IP rights, showing that we cannot completely treat in isolation of the various IP rights. So we cannot say that, let's say, the music industry is only relied on copyright. Of course, they will use trademarks. We cannot only say that, let's say, the automotive industry is only relied on patents. Of course, they rely on patents heavily, but copyright, design, trademark, almost all kinds of IP rights will be important for them. So this is what also this study by the European Commission, the European Patent Office and the EU IPO has revealed. Let's talk about the main IP forms. The best way to demonstrate the various forms of IP is via a real-life example. Let's take the example of a cell phone. You can identify the logo on the cell phone, which will be the trademark. Of course, trademark can be also words, colors, a bunch of things. But let's now talk about the logo. So the logo on the cell phone, that will be the trademark. The shape of the phone is protected by copyright, but also can be protected by design rights as well. The internal structure of the phone, the position of the various microchips, other components to each other, internally in the phone, that can be protected by utility models. The concept of the touch screen or the 4G or 5G mobile technology is protected by patents, actually by a bunch of patents. And do not forget, IP is territorial. You need to seek protection in all those jurisdictions where you intend to conduct your businesses. Software running on the platform of the cell phone is protected by copyright. In the US, there is patent protection for software, as well as patent protection for designs, but not in the EU. From time to time, there are initiatives on the level of policy dialogue to provide a more tailor-made sui generis protection for software. But currently we have copyright, which provides a legal protection for software. Geographical indicators, or GI, is a name or sign used on products which corresponds to a specific geographical location or origin, such as, for example, Champagne or Bordeaux. These are familiar GIs for everyone, I guess. Plant variety rights are an internationally recognized form of intellectual property used to protect unique plant varieties. And because of its economic importance, we need to talk about trade secrets, even if trade secrets are not IP rights, but they are undisclosed know-how or business information which provides a competitive edge for its owners against competitors. Its rules are currently harmonized with an EU directive across the EU member states. If you decide to protect your innovation with trade secrets, then obviously you will be responsible to provide the proper protection for it yourself. If you go for the patent protection, you have to disclose your innovation, but in turn, the state will guarantee the exclusive right to utilize your innovation. Trade secrets does not protect against parallel inventors, whereas patents provide a legal protection also against parallel independent inventors as well. Famous trade secrets are, for instance, the concept of the Michelin tire or the Google's algorithm. In this chart, named the Inventors or Authors Trail, it provides an excellent demonstration of the chain of innovation and the relevance of IP in each stages of the innovation process. At the start, as you can see, the research and development phase, laboratories in the pharmaceutical industry, research and development centers of huge manufacturing companies. This is where the idea is born. And then, in cooperation with the legal department, decision is made about IP filing or to keep a part in a trade secret. This is the part of the IP management, the IP strategy of a company. And just to point out the most important parts of this chain, in the next step, in many cases before you want to start the manufacturing, you will seek financing. And in order to seek financing, you will need to be able to show that there is a strong IP protection for your idea. You will need a strong IP title and a strong IP enforcement regime. And if you bring your products to the market, you will need a good branding protected by trademarks. And if you go towards export markets, you need to make sure that equivalent protection is provided for IP on those markets, comparable to the IP protection enjoyed on your domestic markets. Thank you for your attention.